This is a lecture on the public benefits requirement for charities. The text and cases and materials books are quite useful, but in addition, it is probably worth having a look at the Charity Commission's recent document published in January 2008, URL for which is on the PowerPoint slides. It is important to appreciate that public benefit is used in a number of different ways. In the lecture, we looked at a number of cases which were based on the anti-vivisection case, and in particular a quote by Lord Wright in that case, who said that, as regards the first three heads of charity, that is to say, poverty, education, and the advancement of religion, public benefit may be prima facie assumed unless the contrary appears. Now, it is fairly clear that this quote, and indeed the quotes that we saw in the lectures, are actually about the scope of the heads of charity. That is to say, is the particular purpose for the public benefit in general. They are not about the class of persons to be benefited. Does it benefit a sufficient range of people? Does it benefit, if you like, a section of the public? Now, head 4 is different, the utility head. Under head 4, there is a need to justify utility itself as a public benefit, as well as the range of persons to be benefited. The Charity Commission has recently observed, in January 2008, that the Charities Act 2006 removes the presumption of public benefit for education, religion and poverty charities. There was such a presumption before, but now there is not. I think it is important to realise that this is based essentially on the anti-vivisection quote that we've just looked at, and it is about whether the purpose is of a public benefit in itself. It is not about whether a sufficient section of the public is benefited. Most of the cases that we're going to look at are about the second aspect and not the first. The Charity Commission do, however, go on to talk about what they mean by, or what is meant by, a section of the public. And they consider in particular, for example in relation to independent schools, restrictions based on ability to pay fees charged. And they take the view, I think, that such restrictions should not be too great if the purpose is to remain for the public benefit and hence charitable. Now, I think it's important to note again what this is about. This is about the idea of public access, the idea that anybody can in reality benefit. This, again, as we'll see, is not quite the same as public benefit has been developed, as that concept has been developed in the cases over the last 50 years or so. The court's main concern has been slightly different. It must be remembered that these are public trusts, and in particular that the charities can obtain tax and rates benefits. And therefore the courts have been very concerned to limit these advantages to purposes which are genuinely public, and in particular are not limited to particular families or are otherwise essentially private. To this end, they've developed the personal nexus test, where charitable status is denied if the purpose is related to a named person or named persons. This test originated in the Court of Appeal decision in Recompton in 1945. This is an educational purpose, but the benefits were confined to the children of three named families, and it failed because there was insufficient public benefit. We've also seen the Habanero case, another decision of the Court of Appeal, 1 year later, where a charitable purpose was argued under the fourth head for what was in essence a disaster appeal charity. This was also held to be non-charitable. This time, if you may remember, the benefits were limited to the employees of a particular company, and though these were probably quite large, nonetheless this was essentially a private trust and therefore did not have sufficient public benefit for it to be charitable. The effect actually in Habanero was not to do with tax advantages. Instead, the charity commissioners claimed that the proper money that was left should be used to see prey, and the Court of Appeal held that it should not, but that it should be returned to the contributors. The personal nexus test was approved by a 4-to-1 majority in the House of Lords in Oppenheim against Tobacco Securities Trust Company in 1951. And from that case, and other cases of around that time, we can make 3 comments about what will be regarded as public benefit for the purposes of at least of an educational charity. First of all, it is said, the range of possible beneficiaries. Now I'll come back to that in a moment, but Lord Symonds emphasised the word possible. The range of possible beneficiaries should not be numerically negligible. So we're not talking about a handful of people, we're talking about a reasonably substantial number of people. Secondly, this must form a section of the community. We'll come back to that in a moment when we have a look at Davis against Perpetual Trustee Company, a Privy Council decision a few years later. Thirdly, the persons to benefit must not be connected by a personal nexus. And personal in this context includes companies, so it's not charitable to educate, for example, the employees of a company or the families of employees of a company. And this was so in Oppenheim, even though the company had 110,000 employees. It would even be true if the company was, for example, a nationalised industry, so that, for example, British Rail employed all railwaymen at that time. So you can see that even if the number of beneficiaries is potentially very large, the trust will still fare as a charity if the beneficiaries, or those to benefit rather, are connected by any kind of personal nexus. Now it has to be said that the Oppenheim test has been fairly heavily criticised, and indeed there was quite a powerful dissent by Lord MacDermott in the case itself. However, the reasoning is justifiable, I think, in that if a purpose is to enjoy tax benefits, it should really be a public purpose and not simply for a private group of people or for a private family. And I think that reasoning remains valid, however large the numbers in that group or family are. Lord Symonds also pointed out that the numbers in a company can increase or decrease, and that if you had some number, you'd have difficulty as well in drawing the line. In the 18th and 19th century, there have been a number of cases involving poor relations which had been held to be charitable. Now clearly these did not satisfy the personal nexus test. These were, however, poverty charities, and Lord Symonds in Oppenheim took the view that the poor relations cases, though not necessarily incorrect, should be confined to poverty charities and should be regarded as anomalous. I would also make this observation about Oppenheim. We saw earlier that there is assumed to be a presumption of public benefit under the first heads: poverty, education, and religious charities. Now that may be so in the sense that it is assumed that, for example, education is for the public benefit. But can you really call Oppenheim a presumption of public benefit? It seems to me that this is an application of actually quite a strict and rigid rule, which is quite difficult to satisfy, and that far from being a presumption of public benefit, it operates more as a presumption against public benefit. The assumptions upon which the 2006 Act were based may not have been entirely valid, therefore. A variation on Oppenheim is what might be termed the preference cases. In these cases, the potential recipients of benefit are not actually limited to, for example, the employees of a particular company, but the trustees are directed to, or maybe have power, to prefer those employees of a particular company to anybody else. Now we start with Recoitchant Will Trusts, which is a decision of Mr. Justice Upjohn in 1954. This was precisely such an educational charity, where the trustees were directed to exercise a preference up to 75% of total income in favour of the employees of a particular company. Mr. Justice Upjohn thought that this trust was valid in spite of the preference. That is because the primary objective was valid, and the preference did not render it invalid.